Officer Dave, would you open the courtroom, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Morning. Morning, counsel.
Good morning, Your Honor.
Did you get any pleadings from the other side?
No.
Okay, just give them a couple minutes, see if they're gonna show up. I'll get back to you.
Sure. Thank you.
Wait.
By Jan Seleka. I'm not a fan. Second out. Peter Wolf got the alpha race up next. Still, and then Phil. Stay with us this hour. I'm Jay Pfeiffer. Our lives are full of the unexpected. Once in a while, you can find out a sure thing to come your way, like listening to local news at 94.9 if you want to see there. We'll be here for you, and you're there for us with your memberships at home. If for $10 or $20 a month, go straight to the bicycle and dance music. Call 866-909-9725. Oh my God, that would be CJ FM. Thanks very much for the reminder of the RCJ's fiscal year for 2022. Next week, June 30th. So there's still time to make your pledge to support great music. 866-909-9725 or you can click donate now. That would be prelude to the 19th.
We are on the record calling file 21-171-886, Shores Financial Group versus Vivian Dean. By a notice dated June 9th, 2019, this matter is set for hearing today at 11 o'clock, on the plaintiff's motion to set aside dismissal. It's now 11:15, your appearance.
Good morning, Your Honor. Tina Renyon appearing on behalf of Plaintiff Shores Financial Group,
Bar number.
P81255.
Have you received any pleadings from Ms. Dean?
I have not.
Okay, counsel, why should I set the dismissal aside?
Okay, Your Honor. As already noted, this is plaintiff's motion to set aside dismissal. I would note, as I stated in my motion, that pursuant to court order, the defendant was timely served with a summons and complaint by alternate service. Copies of those proofs of service were attached to my motion.
Attached to the motion, counsel, but not submitted to the court prior to the time the matter was dismissed in response to your purported default. In the motion for your motion, you forgot to mention that although the court had ordered 3 separate types of alternate service, when you requested your default, and I would point out that the court on February 15th gave you a second summons to expire April 18th. On or about March 8th, which is more than a month prior to the expiration of the second summons, you filed proof of service of 2 of the 3 things the court had ordered. You filed proof of service of the first class posting and certified mail.
Mhm.
Noticeably absent was any proof of posting by a 36th District Court officer. Then on May 18th, you filed your default after the expiration of the second summons. The court denied that default because when I reviewed the file and reviewed the register of action, you had not provided proof of posting by the court ordered bailiff as required under the alternate service. You had in essence provided proof of posting of doing 2 of the 3 things the court ordered you to do. It was only when you filed your motion, and that motion was filed in June 6th, 18 month and a half after the expiration of the summons, the second summons, that you provided proof of the posting. I looked both at the file and I looked at the register of action. You did not file proof of posting by the court officer until after the case had been dismissed for your failure to follow the court's orders. Why should I set that aside?
Well, Your Honor, it was my belief and understanding that the proof of posting had been filed.
How could that be
And I
understanding, counsel, when you look at the register of action, and the register of action refers only to first class and certified mail?
yes, I understand.
How could that be your belief?
I understand that, Your Honor. I will say, and with all due respect to the court, I'm noticing that we are filing things with the court via fax, and it's not just this case. So I'm guessing that's probably what happened here. We are filing things by fax, and I'm noticing some things are not being noted on the register of action. So I'm wondering if maybe they got lost in transit, even though we typically do have a successful fax transmission receipt. I think that's probably what happened here. I think my office probably was under the impression that it had been filed. Clearly, the court is of a different opinion than that. However,
let me interrupt this narrative about problems with fax to point out to you that, again, I'm looking at the file, and what you filed in relationship to the proof of service of the first class mailing and certified mailing was an original, including the original certified receipt. So that's not what happened here.
okay.
That's not what happened here. Again, I'm listening.
Okay. Well, Your Honor, I would also point out that, I guess I can't really explain what happened here when it comes to the posting being filed, but the truth of the matter is the posting did happen and it was timely pursuant to the second summons. So, I'm sorry.
I didn't say anything. I'm listening.
Oh, okay. I'm sorry. There must have been a glitch on my end then. So as I was saying, even though there was some sort of a transmission issue as far as filing the proof of posting, the defendant was still served by posting, and that was timely. And I believe the court rule MCR 2.102F allows for the motion to set aside the dismissal to be granted because of the fact that the defendant was actually timely served. My office in absolutely no way intentionally did not file the proof of posting. Like I said, I really can't explain what happened there. We are very diligent about getting those proofs of service filed before we file the default judgment. So at this time, I would request that the motion to set aside dismissal be granted and the default judgment that was filed with my motion be also entered.
All right, this matter is aimed at the discretion of the court.
Mhm.
And while on the one hand, there's certainly concerns about efficiency, there's also an overriding concern, which is compliance with orders of the court. The difference between an order and a request is an enforcement. If I'm not enforcing my orders, I'm not a judge. I'm a disc jockey. I'm doing requests. I don't do requests. I do orders. And in this case, the court's order was not followed. That's clear. Problems you may or may not have in this court with faxes are not relevant in this case for the reason that your original proof of service was filed apparently by either person or by snail mail in relationship to both the certified mailing and the first class mailing, as evidenced by the fact that the certified mailing green receipt is attached to your plea. The court is going to exercise its discretion and grant your motion to reinstate the case. I will permit you to file a default or default judgment. We really expect people to comply with our orders. If I order you to do 3 things and you do 2, that's not what I ordered.
I understand, Your Honor, and I really do apologize for the misunderstanding.
Not a misunderstanding. It's a
Well, for
office to perform.
I apologize, and we will work on ensuring that the proofs of service are completely complied with
You
and
have,
properly filed.
we have a register of action available online.
Yes,
And I noticed that when you filed your motion, you didn't refer to the fact that the register of action, which was available to you, does not show the proof filing of the court officer at the time the other 2 proofs were filed. This is an internal matter with your office, counsel.
okay.
Because the motion is unopposed, because the first 3 ordered methods of alternate service were granted, were in fact performed inside of the time provided by the second summons. The court will grant your motion to set aside the dismissal.
Thank
I
you, Your
will
Honor.
not do this again, counsel.
I understand, Your Honor.
Exercise is when I see your request for a default, I should see all the documents that are necessary to justify that. And in this case, both the register of action and the physical file make it very clear that those documents, the complete set, were simply not provided.
I understand, Your Honor. I do have a question for you, if I may. As far as filing, I did provide a copy of a default or default judgment actually to be a proposed one to be entered by the court. And I can't remember if it was you, Your Honor, or another judge within 36th District Court, but we have, I think it was just this week, we received a request for a blank filing of a default judgment after a default had already been filed. And I just wanted to make sure Did you want when we do move forward with filing the default judgment after a default is entered, do you want it all on the same original form that shows the entry of default, or do you want a separate form and the default
Prefer
attached
separately so that we can make sure that
separately?
the defendant is given an opportunity to respond to the default. If
Okay.
I'm the defendant, because the defendant, of course, got a copy of the order of dismissal, I think this case is over.
Right, okay. Okay, well then we will make note of that. And then did you want me to file a new default, a new proposed default, or is the one that was attached to the motion acceptable?
Let me see.
Sure.
No, you didn't attach a default. Oh, there it is. No, that's just a default request. And it just to send in a default.
Send in a new default, okay.
Yeah, it serves the other side. So that way we don't have any arguments about what the defendant knew or didn't know after they had the reasonable expectation that the case was dismissed.
Okay, so submit a new default along with a proof of service to the defendant of the blank default.
Yeah, and then
Okay.
because you'll have an updated number in regard to your interest and costs and relationship to default judgment anyway.
Correct. Okay, we will get that out as soon as possible, hopefully this afternoon.
Have a good day, Counsel. Thank you.
Thank you, you as well. Bye-bye.
Bye-bye.